All right, our final case on this morning's docket is Williams versus Kids First of Florida, case 24-2207. Counsel for the appellant. You may proceed when you're ready. We'll give you 5 minutes for rebuttal unless you want something other than that.
May I please support Henry Guyton on behalf of the appellants that I will collectively refer to as the Williams family, and I would reserve the 5 minutes support explaining for a rebuttal. Initially, I want to state up front for this court so that there's no confusion. The appellants filed a complaint for civil damages against Kids First, a lead agency contractually and statutorily charged with performing foster and pre-adoption services under their contract with the department. And the purpose of that complaint...
If you prevail on that complaint, there's nothing that would happen in that case that would affect these prior adoptions.
That is the point I was going to make, Your Honor, that there is a civil action for damages. If my clients prevail below, then the only thing they would be awarded is damages. It does not affect the placement of the child.
The adoptive child, RAW, the sister, she will never go back to the...
Unfortunately, Your Honor, unfortunately that appears to be the case under Florida law based on this court's prior decision, but that is not the relief that is being sought in the civil action.
I mean, in essence, that's part of your argument I would think you need to make here.
Yes.
To say, look, they believe we're collaterally attacking that judgment. Your opponents believe we're collaterally attacking the judgment. And you might not be happy with the judgment.
Correct.
That's passed already. It's long past, and nothing's going to happen in this case that's going to change that. Sadly for your side, but it is what it is. Therefore, that should not be a factor, should not have been a factor in the trial court in dismissing the second amended complaint and hamstringing you guys in the filing of the third amended complaint. That's your position. Right?
Exactly, Your Honor. Is that the civil action is the civil action for damages. We, right or wrong, at this point, the focus is on the civil action for damages.
And KFF can be liable in tort.
Correct, Your Honor. They are.
Whether they're even a state agency or not, because there's a waiver of sovereign immunity in their 768.28, but they statutorily have to actually keep insurance.
Correct.
As part of their duties as a lead agency.
Correct. Under 409.993, the Florida legislature required that they keep liability insurance. In fact, not only required they keep insurance, but increased the limits that they would be statutorily liable beyond what other state agencies would be liable, because it specifically recognized the danger that lead agencies such as Kids First can pose to families and children coming under their services.
And primarily what your side perceives as the questionable behavior regarding the Williams children in general, but primarily this one and her older brother.
Yes.
Pertain to the 2017 dependency case.
That's where the action started, but it went throughout.
I know, but primarily that's where you're aiming. I mean, just
and that's what hamstruck us, because when the trial court made its
because the youngest child, the 2021 dependency, that child's with the parents, the biological parents.
That child is currently with the parents, even though we believe that tortious actions were committed against that child as well.
I would suggest that your best route is to talk about the 2017 dependency. You go ahead and use your time accordingly.
Okay, yes, Your Honor. Well, the primary ruling that the court made was its interpretation of 63.182 and whether that statute of repose, which was an adoption statute of repose, barred the civil action. And we would state that based on its plain language, it did not bar that. The statute on its
because you're not seeking to vacate, set aside, or nullify.
Exactly, Your Honor. The civil action does not seek to set aside, vacate, or nullify any termination judgment or adoption judgment. And that is consistent with this court's decision in Manning, which was a 2019 case cited in the brief at 273 Southern 3rd, 214, where it was a similar case where this court examined the statute of repose. That was 95.11.
Oh, okay. That wasn't in the adoption count.
It wasn't an adoption. It was an instruction. But basically, this court read the statute and said, well, just because the civil action relates to something that the statute bars, does that mean it falls under the specific language of the statute? In that case, the plaintiff was suing an inspection company who had inspected her new construction and gave an opinion that there was no structural damage, when in fact she discovered 15 years later that there was structural damage to the property. She sued the inspection company. The inspection company said that the statute of repose barred that claim because there was a statute of repose that barred claims that are founded on the design, construction of a improvement to a property. And this court said, well, just because the statute bars a claim that's founded upon the design and construction, that's not the same as a claim that's just related to new construction, which the court determined that's what her claim was. It was a claim that was based on the inspection company's negligent evaluation of the construction. It wasn't founded upon actual construction itself, design itself. And it says, so therefore it fell outside the scope of the statute of repose because it didn't fall within the plain language. That is our interpretation of 63.1882.
So what the trial judge did in this case, dismissed the second amended complaint, and dismissed certain causes of action asserted there with prejudice because they were related to the 2017 claims, allegation regarding that, gave you leave to amend, to file a third amended complaint, keeping in mind that certain causes of action were dismissed with prejudice. So you then refiled consistent with that, but within the parameters of the order. That then ultimately got dismissed by the order dismissing the third amended complaint, and then a concomitant final judgment was entered. And your position today is we should set aside the final judgment and allow the second amended complaint to proceed, or at the very least, allow us to amend again to basically have not a fresh start, but to kind of go back and say, look, the statute of repose should not be a factor in the trial court's analysis of whether we have sufficiently pled a cause of action. Is
Correct.
That your position?
That is our position.
Okay.
In fact, I think we would ask that we be, if it is remanded, that we be given an opportunity to amend.
That would seem to be the cleanest thing to do.
Yeah.
Assuming that your position today carries the day, that would be the cleanest thing to say, okay, look, trial judge, the statute of repose is not applicable to these civil causes of action, so that there's no misunderstanding or anything. Let the Williams family, using your phraseology today, let them file a fourth amended complaint to assert whatever they have to assert, and then go from that, see how KFF responds, and go from there without the umbrella of the statute of repose.
That is exactly what we're asking for, and I agree, Your Honor. I think that is the best way to go forward. We respectfully believe the trial court just improperly misinterpreted 63.182, and that misinterpretation basically skewed everything that happened afterwards.
Somewhat of the irony in this case is both sides are saying we should apply the supremacy of the text to the reading of the statute of repose. You would think that there's only one supremacy of the text, that it says what it says, right? But,
yeah, I mean, I believe our interpretation of what it said. I don't think there's any ambiguity. I think it says on its face it only bars actions that seek specifically to set aside, vacate, or nullify a judgment of adoption of TPR.
do you believe that the judgment actually has to, the TPR judgment or the adoption judgment actually has to be set aside to seek damages? I mean, analogous to a person gets convicted in a criminal case, it gets affirmed on appeal or no appeal is taken. The defendant who's in jail or prison can't then sue the prosecuting office and say, hey, I'm being falsely imprisoned because of my conviction.
Well, Your Honor, I would say that a termination proceedings under Florida law is considered a civil proceeding, not a criminal proceeding.
Right.
And I would also say that we are in no way attempting to challenge the TPR judgment. In fact, if you read the TPR judgment itself, in that judgment, the kid's first employee testified to the judge, told the judge three falsehoods. She told the judge that Jennifer Frand, who was the KF-related person, told the judge that she didn't intend to adopt Renaya, that was false. They knew at that time that the Frands were intended to adopt Renaya.
These are allegations in the complaint.
These are allegations in the complaint.
We're right here, we're basically on de novo about whether this should have been dismissed.
These are allegations of complaint, and they're also statements that the trial court made in the
I don't
TPR
know,
judgment.
as we sit right now, we're not re-examining evidence. We're saying, oh, these are the allegations that were, you're talking about allegations that were made in the complaint that ultimately got dismissed.
And the point I was trying to make is that the action isn't in any way challenging TPR. The action is, in fact, an action because Kids First didn't follow the representations that they made to the court.
That's the nature of your claim.
Right.
You should be pursued for damages because of what you believe KFF did.
Yeah, they told the court.
Tortiously.
Yeah, they told the court that they were going to find relatives and they were going to have place this child with relatives. That's what they told the TPR court. You
can't talk to us about the testimony about the 2017
okay.
case because we're here just about whether there's pleading should have been.
I understand.
I know that you want to tell a jury at some point about it, but that's really not the focus today.
I apologize.
I need to be more. I should have been more direct with my question. So, go ahead.
No, it's mine. So those are the allegations that are in the complaint, and obviously at this stage, this court has to accept those allegations as true. And based on those allegations, we believe that the claim can be stated. We believe that the trial court's interpretation of 63.182 was incorrect, and that this case should be remanded with directions that this court instruct the court as to the proper interpretation of the statute and allow the plaintiffs to replead. We also make the point that there were 48,000 emails that were produced after the complaints were made that did have factual allegations or illuminated plaintiffs on additional actions that Kids First took that we'd also want to the opportunity to incorporate, which is part of the reason why we were asking for leave to amend on remand. But we believe that this case is really a statutory interpretation case. The trial court interpreted the statute incorrectly. The Florida legislature certainly intended for lead agents to be subject to tort and negligence liability, and that's all the parents are attempting to do. And unless there's any other questions, I'll leave it at that.
Okay, thanks, sir.
Good morning, Your Honor. Attorney Walt Clark, on behalf of Kids First of Florida, the appellee. I don't think you need to reach the statutory interpretation question at all in this case. I think you can affirm on the basis that this is an unauthorized collateral attack on the 2017 TPR and adoption judgments.
How does this attack that judgment?
Because
any relief could be given in the civil case, could it affect what's already happened in the adoption TPR case?
And I think you have to look to the Bain case we cite, which relies upon Heck versus Humphrey. And I know those are criminal cases. I acknowledge that in the footnote. But the concept of law is, I think, what you have to look at here. So you have a court that enters a valid judgment that is not appealed. You then have a second set of judgments which are not appealed. So I'm talking about the TPR judgment followed by the adoption that are not appealed. Going beyond that, we know, because we've asked you to take judicial notice and you accepted it, that there were efforts to vacate those in the dependency court, which were ultimately denied by the judge and affirmed by this court. So we have valid judgments that have been in the books since 2018 and 2019 respectively. And what you're saying now is a losing party to those cases can come back in years later and say it should have never happened, that there was misfeasance, breaches of duties, and it should have never happened. And so
Should have never happened doesn't mean it vacates, nullifies, or sets aside what already happened.
But you're talking about the language of the statute, and I'm talking about the concept of collateral attack. And collateral attack is much broader than that, and I cite the cases, and they're long-standing cases that speak to that issue. And so what you're inviting then is the opportunity, years later, to go back in behind these judgments and attack them, claiming that they should have never happened.
But that's really not, I mean, you talk about the criminal case, post-conviction really, 3850 motions. Those are collateral attacks on the judgment, saying, yeah, I got convicted here, but you know I got convicted because I had an ineffective lawyer. So you have a collateral attack on the judgment because you're asking for relief, saying, Judge, this never would have happened, but for my lawyer was ineffective under the Strickland v. Washington standard. And that then affects the judgment. But as Judge Harris is pointing out, which I agree with, is whatever happens here in this case, that's never going to affect that judgment of adoption or that TPR.
Well,
But if there was misbehavior that went on back, and I'm not saying there is or isn't, they've alleged it, you're basically saying because there's a statute of repose and the 1 year time frame has run, you can't look at all as to whether there was misbehavior, egregious behavior, and, conspiracy, intentional, whatever the causes of action they pled. And based on I'm not sure the plain language of the statute seems to say it prohibits a claim that's seeking to set aside any claim to vacate, nullify, set aside the judgment. This doesn't.
I'm trying to make two distinct arguments. One is, and I cite the case law that's not in the criminal context, it describes collateral attacks generally. And my point is, if you allow that to happen, then what you could have is you have a civil judgment years later that says that they're entitled to money damages because those judgments should not have been entered, even though they remain on the books valid. And so you have inconsistent judgments out there. And if you can do that, then any parent who loses their parental rights and loses children to adoption can then bring a lawsuit, even though those judgments are final, and say that shouldn't have happened. You're allowing then basically the finality of those judgments to be indirectly overturned by a later civil judgment that says that they're invalid because of misconduct. That's the concept.
Well, let me ask them, isn't that the legislative prerogative to clarify that in the statute of repose? I mean, I get what you're saying is that any adoptive parent, take KFF aside from this case, anybody who adopts a child post-TPR, especially if they were part of the plan in the TPR proceeding saying, we're seeking to have an adoption, and here's the person we're looking at to have the adoption. The losing biological parents can come back and say, see, there was a conspiracy between the DCF and the adopting parent, and I want to get damages against the adopting parent. Because they said they made up things at the hearing or the trial.
I understand. And again, so you're opening a door that now, and of course, the adoptive parents are being sued. Their case was dismissed, and that's on appeal. It's not briefed fully yet, and it's a notice. We gave you notice of a related case to that. I want to segue to the statute, though. Let me. I have a chart, and I indicate this in my brief. This is how the statute reads here, but this is how the plaintiffs want you to interpret the statute.
Come up here. Thank you.
And this is in my brief. They want you to ignore the language notwithstanding 95-031 and 95-11, or other statute, or any other statute, notwithstanding an action or proceeding of any kind, to vacate, set aside, or otherwise nullify. And I would focus on the word otherwise nullify a judgment of adoption or an underlying judgment terminating parental rights on any ground.
What does nullify mean?
To render invalid, Your Honor.
Or render null and void as if it didn't happen. And that's not what this statute would do.
I think you can render something invalid by later saying that was wrong. You can't change the outcome, but you're saying now it was wrong and we're going to give money down just because it's wrong. And so this is the dichotomy that I'm trying to express on the collateral attack side. You have valid judgments that say, here's the status quo. And then years later you have civil judgments saying, well, that shouldn't have been the status quo. It's going to still be the status quo, but we're going to give people money because it shouldn't have been the status quo. And that's the inconsistency that I think collateral attack legislation.
But aren't we reading language into the statute then? It should have said, you can't bring an action to vacate, set aside, nullify, or any claim for damages related to this unless you bring within 1 year of the judgment.
Well, I think no, because it says otherwise nullify. And I think the word otherwise has to be given some meaning here. And that's the point I'm driving at. The collateral attack issue really does somewhat overlap with the statutory interpretation issue, in that otherwise nullify, that word has to be given some meaning too. And what about the notwithstanding 95?
What if they took the word otherwise out? How would that change your argument?
It might, Your Honor.
How?
Because it narrows the application of the word nullify.
You have to have it nullified. It has to be a null judgment.
Right.
within a year. And if
So
you're
then
not- you're not seeking to
the
nullify.
otherwise language means some other form of nullification, some other form of invalidity. And so a subsequent civil judgment suggests an invalidity to the original judgments, which are still valid and still binding. And so, again, I think you open the door. Any disgruntled parent who's lost their children through a TPR, years later can bring an action. And again, the statutes of repose here are many, many, many years later. So they could bring an action many years later.
Well, within the statute.
Well, but the statute of limitations has all sorts of exceptions that a statute of repose does not. So we cite the case law that equitable estoppel and fraud in this context do not overcome the statute of repose. So you open the door to adopted families that have been stable for 5, 6, 7, 8 years, now facing liability, or the agency that was part of that process now facing liability for valid TPR and adoption judgments. And
I mean, there are allegations in their complaint as the older brother and the sister, basically, okay, we went through the TPR, then the paternal grandparents, within a week, then started to try the adoption proceeding, and there's the, I can't remember the acronym, the
ARC proceeding,
yeah,
out of Duval.
They were there, they recommended that both the paternal grandparents
Correct.
adopt both. The KFF board member and his wife engage in that and somehow help convince, I mean, I'm not saying it's proof, that's not, they help engage, and all of a sudden, those siblings become separated, and KFF is a board member in some perhaps conflict of interest, as they allege, adopts one of the children away from the paternal grandparents who were being recommended for that, and this side believes that that's an actionable event.
So there are two ways to look at that, Your Honor. So you have the ARC proceeding out of Duval, because it was transferred to Duval, that recommends that the paternal grandparents adopt both. And so the question...
They adopt their grandkids, yeah.
Right, I understand, Your Honor. But that then comes back to the court, and the question is, what happened next? One of two things happened next, Your Honor. Either there was a litigated hearing that resulted in a judge determining that they were going to be adopted separately, which was not appealed, or they reached an agreement to let the separate adoptions go the way they did. That's the only two alternatives coming out of that situation. And again, so you have a valid adoption judgment that's not appealed, and now they're challenging it years later because they don't like the outcome. They either agreed to it, or they had a contested hearing, they lost, and they didn't appeal. And so again, now we're back to a situation where the adoptive family is also before this court on an appeal, having had their, having succeeded on a motion to dismiss their case, which the court will hear whenever the briefing schedule provides. And I think that's the problem here. I mean, if you're going to do that, you're going to potentially upend the system and allow for any number of cases and complaints years after the fact.
You agree that the second amended complaint was dismissed basically upon the trial judge's interpretation of the statute of repose, consistent with what you're arguing?
Yes, Your Honor. And she made acknowledgement that I had made the collateral attack argument, but didn't rely on that.
Right. And then so the third amended complaint was limited to asserting causes of action unrelated to the 2017 dependency activity.
Right. The 2019 case arose 7 months after the adoption of the boy, a year more after the TPR. The biological dad had the boy in the car with him, and he was arrested for DUI. And so then a TPR case,
Dependency.
a dependency case was started as the grandparents. And I would note that, yes, there is indication in the record that KFF had identified the adoptive parents of the girl as a potential placement for the boy, because, of course, they have the sibling. The boy never went there. The adoptive mom was going to offer to pick him up. She didn't do that. DCF allegedly attempted to pick him up from daycare. That didn't happen. Instead, there was a dependency shelter hearing, and the boy was sheltered with a maternal aunt, and then returned to the grandparents through that dependency process. I see, and those are the allegations, and I see no claims against KFF for that. The 2021 case is even more remote. baby's born in 2020 to the original birth parents. A year later, DCF brings a dependency petition. I asked you, I filed a notice of supplemental authority on a case, TP versus Department of Children and Families. It came out this year. It was decided on April 9th of 2025 in the 4th District. And in a footnote 2, they talk about twins and then a half-brother. And there's a termination of parental rights for them. And with respect to the twins, it was found that the parents engaged in egregious conduct in violation of Chapter 39 and TPR. With respect to the half-brother, the trial court terminated the father's rights to the half-brother because of egregious conduct. To one child is grounds to terminate a parent's rights, as to another, citing VS Department of Children and Families, 322 Southern 3rd at 1153. And the point is, so DCF files a case for the older boy, for the newborn in 2021. He never leaves his parents' care, and 6 months later they dismiss it. There's nothing there to suggest that KFF, in those are the allegations that KFF
Well, let me,
wrong.
if we collectively come to a conclusion that the statute of repose should not have been considered by the trial judge in evaluating the sufficiency of the complaint.
Correct.
And it appears that that was certainly a factor in how the Williams family had to frame the third amended complaint. Wouldn't it logically then be appropriate to let them go back and amend the complaint for the fourth time with the understanding that the statute of repose is not a factor in considering the sufficiency of the allegations?
So the statute of repose only applies to the 2017 claims, and KFF has never argued otherwise. And the 2019 case stands entirely on its own. This is 7 months after the adoption, a year plus after the TPR, and the biological dad has the son that's now been adopted by his parents in a car, and he's arrested for DUI. That case stands separate and apart on its own set of facts. What happened? There was a dependency case filed, the maternal aunt sheltered for a while, and then he went back to the grandparents. Those are the allegations. They don't depend upon what happened in the 2017 case.
Well, then it begs the question, then they shouldn't have dismissed this. If the statute of repose doesn't apply, then they shouldn't have dismissed, the trial judge shouldn't have dismissed the second amended complaint. I mean, if I'm understanding what you're saying, it's like the third amended complaint is only under 2019 and 2021.
Right.
We're not arguing the statute of repose. Trial judge dismissed it. That's okay. There's no claim under a non-statute. There's no non-statute of repose claims here. But the tail that wags the dog is the 2017, of which they were precluded from bringing that action again. And if we think that it is actionable, whether it has merit or not is not what we're here.
Understood.
Whether it's actionable or not because the statute of repose didn't preclude it, it seemed like the route would to let them go back and with directions to the trial judge saying, you know, if you get a motion to dismiss the fourth amendment complaint, don't factor in an analysis of the statute of repose. Just look at the allegations of the fourth amendment complaint, whether they, you know, allege sufficient elements of each cause of action. Well, why wouldn't that be the?
If you
fair,
look,
I mean, I know pragmatism and fair sometimes are wild concepts in DCA land,
but if you look at the judge's order dismissing the second amended complaint, she takes up the 2019 and 21 claims separate and distinct, like she does in her order dismissing the third amendment complaint. She never confuses them. I don't understand their argument that somehow the fact that she dismissed the 2017 claims on the statute of repose prevents them from appropriately alleging claims related to the 2019 and 21 case. They're separate and distinct. They happen at different times under different circumstances. Yes, I understand that because of the 2017 case, the future came into play. But KFF never argued the statute of repose had anything to do with those two cases, and the judge never went there either.
so then it's just a de novo review, non-statute of repose, and if we think that, it's a voluminous complaint, and if we think that they've alleged enough, if not too much, alleged enough, then we could just simply reverse. I know you don't want that in. We would reverse saying we think that these causes of action are sufficiently pleaded, therefore the judgment's reversed.
Well, if you conclude the statute of repose shouldn't apply, or the alternative argument that this is, you think this is an okay collateral attack, or it's not a collateral attack at all, then yes, I mean, that's where we're at, you reverse.
Go ahead, you're 20.
No, I mean, my position's been stated in my brief, and I think I've argued as effectively as I can.
Okay.
Thank you, Your Honor.
Thank you. Counsel, you have just over 8 minutes.
Okay, briefly, Your Honor, I'll try to be brief. Your Honor, the Williams family's view of this case is that this was a comprehensive civil conspiracy intended to get the Franz alternate children of the Williams family, and that they weren't separate and distinct, but that the trial court's dismissal of the complaint was based primarily, if not also exclusively, on the fact that she misinterpreted the scope
Well,
of
Mr. Forrest says, okay, statute of repose aside, the trial judge addressed the 2019-2021 dependency case related allegations in your recent amended complaints, and that wasn't a factor in her dismissal. It simply was those claims are insufficiently pleaded. Forget there's any statute of repose or anything. You bring causes of action. They're either sufficiently pleaded or not. You're on your third one. The judge says you just haven't met, and obviously the ability to amend diminishes over time.
Mm-hmm.
And the trial judge says, well, she, in her view, the method limit, you still haven't pleaded it sufficiently. Statute of repose aside. I think that's somewhat of Mr. Poor's argument here. I mean, he makes his emphasis the collateral attack discussion, but even if we set that aside for a moment during your rebuttal, how is he inaccurate or incorrect on that? That you just didn't sufficiently plead causes of action related to 2019 to 2021?
Well, one, I would say that the Williams family were hampered in their ability to plead because the actions that happened in the later proceedings all flowed from Kids First's desire to capitulate or to the desire of the Franz to get these children to them. And so you have to understand the later actions in the context of the first actions. So
is that the pseudonym for the actual names of the parents?
that is a pseudonym
in case we write something, whatever.
Yeah, for confidentiality, we decided to use the word the frames. So I think that the Williams family were unfairly hampered in their ability to plead the claims. It was clear that the third amended complaint was merely an attempt to get around the limitations that the trial court imposed, and it would be unfair to evaluate it without a fair opportunity to plead those causes of action with an accurate understanding that 63182 does not apply. Now, I did want to hit some of his allegations regarding the Bim case. One, this is a motion to dismiss. As you can see from his argument, he's trying to bring in a lot of facts that aren't stated in the complaint that are based on other cases. And I don't think the trial court itself did not conclude that our causes of action were a collateral attack. She did not make that finding. She solely based it on her interpretation of 63182. So you would have to apply the Tipsy-Coachman doctrine to get to the arguments that counsel is making. And I think based on this record, you can't do that at a motion to dismiss stage. The other thing is that the causes of action are an action against the negligence and tortious conduct of Kids First. It is not, the courts and the judgments didn't make any finding that Kids First did not have a conflict of interest. They didn't make any finding that Kids First had properly evaluated the grandparent. None of those findings are stated in either of the judgments. So any of the damages that we're alleging or the cause of actions that we're alleging are not inconsistent with the judgments, nor do they require any reversal of any finding that the judgments were based. As I mentioned before, in the TPR judgment, Kids First told the judge that they were going to place these kids with relatives. That's what they told the judge. That's what he based part of his decision on, is their representation that Renaya was going to be placed with relatives. They didn't do that. In fact, they knew they weren't going to do that at the time they made that representation. That's what this case is about, the damages flowing for their failure to follow through what they told the judge to do. They're afraid to follow through what the statutes require them to do, because the statutes require them to make every effort to place the children, to make every effort to keep the siblings together, to not introduce conflicts of interest or place the children with people who would have conflicts.
Why wouldn't that have been an appellate, a direct appeal issue, or at least an action brought within 1 year to set aside if there was this misrepresentation by them regarding the adoption?
Well, it's not based on that. I'm pointing out the misrepresentation. It's based on the actions of Kids First, both before and after the TPR judgment. And the other thing is, Your Honor, is that Kids First didn't, the Williams firm didn't discover these facts until long after the TPR occurred. They didn't know that the frames were conflict related, that Kyle Frame was the director of Kids First until I believe over a year, until the second action, so after 2019, that's when they discovered that fact. And if you, and the reason this is important is, if you listen, he made a, I guess, slippery slope argument, but what's the counter argument? What if it wasn't a conflict of interest? What if somebody said, hey, I'm gonna pay you $50,000, get me a baby, and Kids First decides, okay, we're gonna start this TPR proceeding, we're gonna make representations to the judge, and then we get this TPR entered, and when the parents try to find out information, they do what Kids First did here, where they try to fight against any disclosure of anything from the files, fight against any disclosure of the emails, which is what they did. In fact, there was a case before this court that Baker was one on that panel, which the whole thing was about them fighting against access to the record. So all they do is fight.
I was on the panel. I wrote it.
Oh yeah, yes, I apologize.
So I'm familiar.
Yeah, so what they're saying is, hey, all we got to do is fight for a year, and if we can get past that year, then we can escape all civil liability for our actions against any parent.
I mean, so the focus of this civil litigation, I mean, because the TPR litigation regarding the sister was whether she was abused, because and certainly she had a lot of significant injuries, but it was litigated as to whether she suffered from a medical condition that caused it, that was unrelated. And the Williams side, the birth parents lost that.
They lost that.
Well, it is what I'm just saying. Actually, that's what happened.
Yes.
And then so at that point, then the children are going to be adopted. And the angst that the Williams family is having is what KFF's involvement was regarding, in essence, from that point forward, because the paternal grandparents were going to adopt those two, and it turned different for the girl.
The Kids First had an obligation under the statutes to provide conflict-free services to both the Williams family and those children, and they didn't do that. That, based on our allegations of the complaint, they absolutely didn't do that, and they should be held civilly liable for damages resulting for their. Because
they didn't have any angst with the boy being adopted, the older brother being adopted. In fact, he did get adopted by the paternal grandparents.
He was with the. Well, I mean, based on allegations, I think they did make efforts to try to get him too. But initially he was placed with the paternal grandparents. Eventually, adopted. But again, the case isn't about the findings of the TPR or the adoption judgment. The case is about the negligent, tortious conduct of Kids First. The Florida legislature plainly states that lead agencies can be liable for their conduct, and that's what that case is about. It doesn't require any reversal or vacation of either judgment, and the judge did not make any finding that Kids First complied with the law, complied with the statutes, and in respect to the actions that we're alleging. So with that, Your Honor, I would end my argument, and thank you all for your time.
All right, thank you, sir. Again, very well briefed, well argued case by both sides. This time the court stands adjourned.
All right.